Can you grab those guys? Oh, no. No, just put them right there. Okay. All right, everybody be seated. I think we're done with testimony with you, so you can go get some sleep.
Okay.
All right, take off. You're welcome. Is she relieved from her subpoena?
We don't have.
I don't think we have a subpoena on her.
Okay.
Yes.
Yeah. All right. Enjoy your night. All right. Two things. One, those are the stipulations. We did print them off. I printed off whatever you sent us through the email. So yeah, each of you grab a copy of it, and then the rest are for the jury, I believe. You can just leave them on the. And then and there's an extra one for the court reporter. We only have one for each.
We'll try to share.
Okay.
Yeah, we'll turn them in after
Those are going to the jury. The rest of those go to the jury.
I'm going to collect them back after we review it. We're all going to review it real quick.
Oh, okay. Yeah. Go ahead.
I'll just review it, Judge.
Yeah.
Okay. And then the other thing is I just took that and made it 14 font and double spaced it for myself to be able to read. So.
I always do.
And then there was an issue of the exhibit. I know it's medical records, right?
They are, and they're authentic by stipulation, but in terms of the statements, they're either statements for purposes of medical diagnosis or statements from the treatment providers that have independent indicia of trustworthiness because they're essentially for the same function. So I believe that they should be entered into the record as substantive evidence.
Counsel?
I'm not necessarily objecting to them being admitted. I guess there are only very small portions of 266 that were testified with this doctor, and if there was a request from the jury to see all of 266, I would only want the portions that were testified to be observed, and we can deal with that.
We can work that out.
Yeah, and okay, so 266 is received, and then if usually I don't send those things back to a jury anyway, but
Figure out what they say.
okay, and then we'll go, if requested, we'll deal with that issue at that point. Okay, anything else we need to talk about before I'll let you take your break?
I'm seeing one typo that survived here, page 1, fourth paragraph down.
I don't
concluded that the discolorations, bruising were consistent with the stair fall. I think the language that we ultimately settled on as the discolorations were consistent with the reported stair fall. Is that correct, Mr. Torbenson?
I'm just trying to find it.
Where is it?
Page 1, fourth paragraph down, midway through the paragraph.
Rather than were also was supposed to be the word was?
No, it just reads, the way it reads is concluded that the discolorations, bruising were consistent. I think we intended to say concluded that the discolorations were consistent.
Just remove the word was. Is that what you're saying?
Well, I mean, discolorations, bruising is also there. I think we talked about this where we wanted the term discoloration used because that's how it was described in the report. But
Okay, so it would say Dr. James Hogan evaluated Haley's bruising and concluded that the discolorations were consistent with the reported stair fall.
that's my request.
Okay, I have no objection to that. So remove bruising and was.
I mean, if the court just wants to strike that from its copy like that, I just noticed that made it into the.
Well, we could just strike them. Tell you what, let's redo the first page. I don't know if you sent it to me sent it to the court as a looks like no, here it is. Okay. We can reprint the first page if needed. Why is that happening? Hold on a second. All right, so let's correct that one.
And I'm sorry.
Go ahead, might as well.
I think Attorney Zacher and I agreed that the very last sentence would say that you may infer that evidence that was deleted from the 2011 case would have been favorable to Ms. Dikeman.
We did agree on that.
So I would ask that that be added to that last sentence.
Wait, this is page 4?
The very last sentence in the stipulation.
You may infer that the evidence that was deleted would have been favorable to Ms. Dikeman. What did you say it was supposed to say?
You may infer that the evidence that was deleted from 2011 would have been favorable to Ms. Dikeman because the appeal period ran in 2013, so I don't think they get that presumption for 2013.
Okay.
My understanding with the 2013 is that we don't get that presumption because of no contest plea to neglect.
Okay. So looks like we just need to reprint the whole thing.
This is still saving hours of testimony, Judge.
No, I appreciate that. No, I get that. I get just one small tree every day. Actually, we're doing better nowadays. So let me, okay, we'll just get rid of the copies we have. We'll redo it. Just be easier. Anything else, since I'm making the change? Make
My
sure
quick read through, I don't see any other errors.
If there's anything else, it's on us now.
Okay. Right.
If the court needs pronunciation, it's pronounced phalanges.
Phalanges?
Phalanges.
At least there's no ischiopubic or synchron.
Yeah, thank you. Thank you. All right. So 10:30, maybe 10:35, the way things is going to go. All right. Thank you. Everybody's present. We've given you our newest copy. Hopefully that's good. So when the jury comes in, what the plan is that I'll tell them we have a stipulation to read to them. They actually have a copy of the stipulation on their chairs. Anything we need to talk about before we bring the jury in. Just to fully explain, I'll read the stipulation, then I read the cautionary instruction. That's what I'm planning to do. Any concerns from the state?
It just strikes me that we've had the other acts come in for Mr. Pedrin as well, and we have not read a cautionary instruction as to that. I don't know if there's a way to
I mean, I can
address it now as to different evidence regarding other acts involving both Ms. Dikeman and Mr. Pedrin.
the only issue there is, and I will consider it the final part partially because this is specifically a cautionary instruction because of the defendant and the propensity, the question of you using, this is a very specifically for the defendant. So it might be confusing because obviously propensity evidence is not an issue with a witness per se, necessarily, now that I think about it, but it's obviously a constitutional issue for a defendant in a crime, in a case. So for right now, I think that might be something we can talk about at final jury instruction. Mr. Zacher, Mr. Bowles, any concerns about how we're going to proceed?
Not with the stipulation. I'm looking at some of the tables that the state provided me now.
Okay. All right. So let's bring the jury in, and then we'll do the stipulation, and then you can call your next witness. Everybody may be seated. Ladies and gentlemen, the The attorneys have come to, the parties have come to a stipulation on some facts and on these other acts. We gave you a copy of it simply because it's very long. We are going to take it back and then we can talk about whether it would go back at a later date. But I'm going to read the stipulation to you because that's required to put it on the record. You're welcome to follow along, of course. And then there will be a cautionary instruction about other acts I'll give you at the very end. We're not at the end of the trial at all. We're just doing this at this moment. There's one more witness at least from the state. So stipulation on other acts evidence. The parties have stipulated that on July 13th, 2011, 21-year-old Haley Tapscott suffered extensive skull fractures involving the right parietal vault and the right suboccipital area into the posterior fossa. The posterior fossa fracture is slightly depressed and crosses the transverse sinus. In addition to the skull fractures, Haley Tapscott's scalp hemorrhaging, cerebral infraction, and traumatic encephalopathy, along with multiple bruises on different areas of her body. Josie Dikeman called the nurse advisory line after observing.
You said 21-year-old instead of 21-month-old. I don't know if that's important.
Thank you, 21-month-old. That's why I gave it to you to read. And I sometimes skip over things, so excuse me. Josie Dikeman called the nurse advisory line after observing that Haley was lethargic and unable to walk and brought her to Gunderson Health Systems for treatment. Ms. Dikeman reported that Haley had fallen down a staircase at 11:30 a.m. and that the baby gate she and her partner, Dustin Barnes, had previously placed over the stairs had broken and was not installed before the fall. La Crosse police investigator Tony DeLapp walked through the home and did not note any facts inconsistent with Ms. Dikeman's report of the broken baby gate. Ms. Dikeman was the only caregiver home with Haley when she was injured. Haley's injuries were suspicious for non-accidental trauma. Haley was evaluated by multiple physicians while hospitalized. Neurosurgeon Dr. Edison McDaniels examined Haley and reviewed her head CT imaging. On July 13, 2011, at approximately 6 p.m., Dr. McDaniels observed a brownish yellow bruise behind Haley's right ear that looked to him to be older. The parties have agreed that it is it's impossible to date a bruise to a specific time frame without histological testing. Dr. McDaniels concluded that her injuries were concerning for non-accidental trauma through the mechanism of a reported stair fall could not be ruled out. Pediatric intensive care physician Dr. Karen Richmond evaluated Haley and noted concerns about bruises that appeared to be of different ages and in places that don't seem to be consistent with mechanism of injury. Dr. McDaniels and Dr. Richmond were unwilling to classify Haley's injury as abuse when interviewed by La Crosse police investigator Tony DeLapp on July 14, 2011, and stated that Haley's injuries were also consistent with a fall down a flight of stairs. However, they considered that explanation unlikely. On July 14, 2011, at approximately 7:30 p.m., dermatologist Dr. James Hogan evaluated Haley's bruising and concluded that the discolorations were consistent with the reported stair fall. Dr. Hogan concluded that there were no other abnormal etymologies from the bruising he observed that suggesting a different mechanism of injury from the stair fall. Dr. Richmond consulted child abuse pediatrician Dr. Ann Budzack about Haley's injury. Dr. Budzack ultimately concluded that while a fall downstairs was unlikely in her opinion to produce the severity of injuries Haley Tapscott sustained, she she could not rule out a fall down the stairs as the cause of Haley's injuries. Dr. Richmond also consulted with pediatrician Dr. Kelly Hodgson-Klein, who regularly evaluated children for non-accidental injury. Dr. Hodgson-Klein also declined to conclude that Haley's injuries were the result of a non-accidental trauma, though Dr. Hodgson-Klein also felt a fall down the stairs was unlikely to produce the severity of injuries sustained by Haley Tapscott. Ms. Dikeman was not convicted of any crime related to Haley's injuries in 2011. On January 17, 2013, 3-year-old Haley Tapscott, date of birth 10/8/2009, was admitted to Gunderson Lutheran Hospital from June of 2012 through January 17, 2013. The primary caretakers for Haley were Haley's father, Dustin Barnes, and Dustin Barnes' girlfriend, Josie Dikeman. Haley was admitted to Gunderson Lutheran for numerous health concerns, including weight loss, hair loss, significant swelling of her left foot, X-ray studies revealed healing fractures to the second, third, and fourth phalanges on Haley's left hand, as well as the distal second and third metacarpals. As to Haley's right hand, the proximal shaft of the third and the fourth phalanges were also noted to have postural changes consistent with healing fractures. One physician, pediatrician Ravi Naik, believed that Haley's hand X-rays showed fractures and diagnosed her with non-accidental trauma. Another physician, orthopedic surgeon Robert Volz, opined that the X-ray images of Haley's hand demonstrated possible healed or healing fractures, but he did not conclude that the hand X-rays demonstrated definite fractures or constituted evidence of non-accidental trauma. Dr. Volz agreed that Haley's foot injury was concerning for non-accidental trauma. It is unknown how Haley sustained her injuries or whether any injury to Haley's hand occurred while she was in the care of Josie Dikeman and Dustin Barnes or at an earlier time. Neither Haley's caretakers, Josie Dikeman or Dustin Barnes, took Haley to a number of scheduled doctor appointments. Doctor appointments were regularly rescheduled, canceled, or missed as follows. An appointment scheduled for October 2nd, 2012 was rescheduled to October 23rd, 2012. The October 23rd, 2012 appointment was rescheduled to October 30th, 2012. Neither caregiver brought Haley to the October 30th, 2012 appointment. Dustin Barnes canceled an appointment for Haley on December 10th, 2012. On December 19th, 2012, appointment was canceled with a notification that the family had a problem with transportation. Neither caregiver brought Haley to the December 26th, 2012 appointment. Neither caregiver brought Haley to the January 16th, 2013 appointment. Haley attended a doctor appointment at Gunderson with Dr. Head on December 4th, 2012, where Dustin and Josie expressed concerns that Haley's balance and gait and inquired about medical imaging to address it. Haley attended a doctor's appointment at Gunderson with Dr. Manson on December 6, 2012. Prior to June of 2012, Josie Dikeman and Dustin Barnes were not the primary caretakers of Haley. During the time frame that Josie Dikeman and Dustin Barnes served as the primary caretakers for Haley Tapscott, i.e. Haley lived with Josie Dikeman and Dustin Barnes, Haley Tapscott went from the 85th percentile in weight to the 6th percentile in weight, and after being hospitalized from January 17, 2013, Haley Tapscott began to gain weight again. On December 6, 2012, medical note by pediatrician Dr. Stephen Manson, noted that Haley had recent weight loss, but that Haley had been significantly overweight before moving in with Dustin Barnes and Josie Dikeman. Haley was diagnosed with celiac disease during the January 2013 hospitalization. And it is unclear whether a celiac condition contributed to her weight loss. Dustin Barnes was questioned by Detective Linnea Miller about Haley's eating habits, and Mr. Barnes said that he was restricting her food because of his belief that she was overweight. Since Mr. Barnes has since died and is unavailable to cross-examine, you may give his statement in 2013 whatever weight you believe it deserves. During the time frame of June 12th, 2012, let me try that again. During the time frame of June 2012 through January 17th, 2013, Becky Eilers, Ms. Dikeman's mother, lived in the lower portion of the same residence as Josie Dikeman and Dustin Barnes. In that time frame, Becky Eilers observed Josie Dikeman and Dustin Barnes make Haley sit at the dinner table until Haley finished her food. According to Ms. Eilers, Haley was the only child made to sit at the table until she cleared her plate. Josie Dikeman and Dustin Barnes would also Josie Dikeman and Dustin Barnes would also make Haley sit on the toilet from between 15 to 45 minutes with her hands on her head because Haley had played with materials inside the toilet when her hands were at her side. GME, who was near the same age as Haley, was not made to sit on the toilet. During these times, Becky Eilers would sometimes see Haley pout and cry. Becky Eilers believes Josie Dikeman treated Haley differently than Josie Dikeman's child at the same age of GME. Josie Dikeman and Dustin Barnes allowed GME to stay up late. Haley was not to stay up late. Josie Dikeman and Dustin Barnes allowed GME to wear pull-up diapers. Haley was not in pull-up diapers and would sometimes be put in timeouts for having accidents in her pants. Josie Dikeman and Dustin Barnes had a potty in Haley's bedroom to stop her from getting up in the middle of the night and falling down the stairs. Child witness GME-R was interviewed and verified that Josie Dikeman and Dustin Barnes would make Haley Tapscott sit at the dinner table for a long period of time or sit on the toilet for an extended amount of time if Haley had an accident. GME, Josie Dikeman's child at the same age as Haley, was not made to do either by Josie Dikeman or Dustin Barnes. Josie Dikeman and Dustin Barnes also used a baby gate to keep Haley Tapscott inside of her bedroom during the night until morning. Neither Haley Tapscott nor GME were allowed out of their bedrooms unless Josie Dikeman and Dustin Barnes were awake. GME-R told investigators that Haley needed a gate to keep her in her room because she would crawl over obstacles if the adults were not awake. Child witness GME-R stated that Ms. Dikeman and Mr. Barnes would occasionally have Haley hold out books as a punishment when she had accidents potty training, but clarified that this occurred a long time ago. Before June of 2011, GME-R is the only witness that claims to have seen this punishment. Other children in the home were not made to hold books out in the same way. Paula Hernandez, Dustin Barnes' mother, witnessed Haley Tapscott's left foot days before Haley was admitted to the hospital. Haley was limping and her left foot was swollen and described as huge. When Paula Hernandez asked Josie Dikeman about Haley's foot, she reported that Josie Dikeman said it was fine. Paula Hernandez, who witnessed Josie Dikeman treat Haley Tapscott differently than Josie Dikeman treated GME. If GME had an accident, Josie Dikeman would change GME right away. If Haley had an accident, Josie Dikeman and Dustin Barnes would not immediately change her dirty diapers. Every member of the split-level home where Josie, Dustin, and Haley lived, including Becky Eilers, Eddie McGurr, GME-R, and ZME, told investigators that they did not see Josie Dikeman or Dustin Barnes intentionally harm Haley, but all also expressed concern how Haley was cared for. Dustin Barnes told Detective Miller that he had never witnessed Ms. Dikeman physically harm Haley. As before, since Mr. Barnes is not available for cross-examination, you may give this statement whatever weight you decide to give it. Ms. Dikeman also reported that she did not see Mr. Barnes harm Haley. On September 9, 2013, Josie Dikeman and Dustin Barnes pled guilty to child neglect as a party to a crime related to their actions towards Haley Tapscott. Party to a crime means that the defendant either 1, directly committed the offense, 2, intentionally aided and abetted or assisted someone committing an offense, or 3, were part of a conspiracy to commit the offense. Neither Josie Dikeman nor Dustin Barnes were charged with intentional child abuse for Haley's injury. Disposed evidence. Evidence from the 2011 and 2013 investigations have been destroyed pursuant to the police agency's data retention policies. Evidence from 2013 was destroyed following Ms. Dikeman's conviction. The records were not destroyed until Ms. Dikeman, time to appeal her 2013 conviction, had passed. Deleted evidence includes photographs, recorded interviews, and police reports, and may have included facts helpful to Ms. Dikeman's defense in this case. You may infer from the evidence that was deleted 2011 would have been favorable to Ms. Dikeman. Cautionary instruction. You don't actually have a copy of this. Let me just read this to you. Evidence of other acts or conduct of the defendant. Evidence presented. Evidence has been presented regarding other conduct of Josie Dikeman for which she is not on trial. You may consider this evidence only for a limited purpose and not to conclude that the defendant has bad character or general tendency to commit crime. You must not use this evidence to decide, because the defendant allegedly committed another act at some other time, the defendant must have committed the offense now charged. Specifically, evidence has been presented that the defendant was involved in prior incidents in 2011 and 2013. You find the conduct did occur, you should consider it only for the issue of identity. You may not consider the evidence to conclude the defendant has a certain character or certain character traits, and that the defendant acted in conformity with the trait or character with respect to the offense charged in this case. Definition. The evidence received on the issue of identity is that the prior conduct of the defendant is so similar to the offense charged that it tends to identify the defendant as the one who committed the offense charged. Propensity-free reasoning requirement. To use this evidence properly, your reasoning must be propensity-free. That means you must not reason in this way. Because the defendant committed another act of crime, she probably acted in the same way again. That kind of reasoning is forbidden. You cannot follow this if you cannot follow this propensity-free line of reasoning, you must disregard the other act's evidence entirely. You may consider this evidence only for the purpose I have described, giving it the weight you determine it deserves, and it is not to be used to conclude the defendant is a bad person or for the reason of is guilty of the offense charged. So what we're going to do is collect the stipulations at this point in time. That instruction will be read again later on, just so you know. Are we ready to proceed at this point?
Yes, Your Honor. State will call Investigative Sergeant Rich Amundson.
And one last thing. I do apologize for stumbling over words. The medical terms I am not great with, as you can tell. Go ahead.